Student is a platform for law students who come here and deliver a lecture on the topic of their choice. Today we have with us law student Pushti Nathwani. She is going to speak on Article 21, Right to Life. She is from KES Shri Jayantilal Patel College of Law. So without wasting further time, I would request Pushti to commence with her lecture. Thank you.
Hello everyone, myself Pushti Nathwani, and today I am going to talk about one of the most crucial topics, that is right to life. This right is conferred upon every citizen of India. This right is enshrined under Article 21 of Indian Constitution. Let us first understand what these fundamental rights in our Constitution mean. Article 12 to 35 of Indian Constitution tells us about various fundamental rights. Fundamental rights are basic human rights given to every citizen of India, irrespective of the caste, religion, gender, place of birth, etc. Why are they called fundamental rights? These rights are enshrined in the Constitution, which guarantees them. Second, they are enforceable by the courts. In case of violation, a person can approach a court of law. How many fundamental rights do our Constitution possess? There are total 6 fundamental rights in our Constitution. First, right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. Coming to our today's topic, let us talk about right to life. Do you all think, looking at the things that are happening around us, the Article 21 is really justified? Taking the recent case of Article Medical Law College, don't you all think that the girl had an equal right to life and personal liberty? Don't you all think there's sheer violation of her right? So let us first understand what is a right. Rights are ethical, legal, social, principles of freedom or entitlement. That is, rights are fundamental normative rules about what is allowed to people and owed to the people by the legal system, social convention or ethical theory. Moving on to the background of this principle, fundamental rights are not new to our Indian Constitution. They were first recognized in the Magna Carta of England and also in the US Constitution. Internationally, on the broader level, Universal Declaration of Human Rights also recognized the fundamental rights earlier. Article 3 of the declaration says every person has the right to life, liberty and security. Further, Article 9 provides that no person shall be subjected to arbitrary arrest, detention or exile. Understanding Article 21 of our Indian Constitution. Although this article is couched in a very negative language, this right is available to all the persons, including foreigners. And these two rights have been given paramount importance by the courts. Protection against arbitrary privation of life no longer means that protection against physical injury or death, but also means that the right to live with human dignity and respect. In fact, citizens who are detained in custody or convicted as under trials are also given subject to reasonable restrictions. The state cannot violate their legal rights merely because they are convicts or under trials, as it doesn't cease to be a human being. It must also be noted that protection of Article 21 is extended to foreigners as well. The same is confined to the article of life and liberty and does not include the right to reside or stay in India. It has been held in the case of Sarbananda Sonawal versus Union of India that the government is empowered to take away the rights from these foreigners whenever necessary, as it is absolute and unlimited right. And there is no provision in our Constitution that fetters this discretion. Moving on to the interrelationship between 14, 19 and 21 article of our Constitution, as discussed above, the interrelationship between these articles has been growing since years. Article 19 and 21 goes hand in hand, and the procedure established by law restricting these rights should stand the scrutiny of other provisions as well. So, any law that encroaches upon one's personal liberty must not only pass the test of Article 21 but also pass the test of Article 14 and 19. They are meant to be read together and interpreted together. So, their immense collective importance has given them the name of golden triangle in jurisprudence. Scope of Article 21. Article 19 and 21 goes hand in hand. Therefore, any law encroaching any one of the personal liberty must not only pass the test of Article 21 but also pass the test of Article 14 and 19. They are meant to be read together and interpreted along with. The immense collective importance has given them the name of golden triangle in jurisprudence. Moving on towards the scope of the Article 21, there are various rights covered under Article 21, and we are going to look onto various judgments as well. First right is right to live with human dignity. It is not enough to ensure that a person has a right to live. An essential element of life is living a life with human dignity and respect. Each person has been guaranteed the right to live with dignity, which means having access to necessities of basic human life, as well as autonomy to one's personal decisions. The landmark judgment of Occupational Health and Safety Association versus Union of India. In this case, a non-profit organization filed a petition seeking guidelines for occupational safety and health conditions of workers. This was with a view of workers facing various skin diseases and lung abnormalities. The court recognized the state's duty to protect the workers from dangerous or unhygienic working conditions and remanded the matter to various high courts to look into the issues of various industries, especially the one working with thermal power plants. The next one is right over one's intimate relationship. This right was established in the case of Navdeep Singh Johar versus Union of India. In this case, the petitioner NGO filed a writ petition challenging Section 377 of IPC, saying that it criminalizes sexual acts between LGBTQ community and it is violative of the Article 14, 19 and 21 of the Constitution. The court, applying the principle of human dignity, said that Section 377 was violative of this Article 14, 15, 19 and 21 of the Constitution to the extent that it criminalized consensual sexual acts between LGBTQ adults in private. Hence, sexual acts between LGBTQ adults conducted with free consent of parties involved were declared legal, and Section 377 was decriminalized. As we can see that human dignity is not a straitjacket idea. Rather, it involves many rights and freedoms which enables a person to live a life without encroachment upon his or her self-respect, pride or safety. Next one is right to livelihood. To survive, a person requires access to financial and material resources as well. The law recognizes that every person, whether it be a man or a woman, should have right to proper livelihood, including basic necessities like food, water, shelter, clothes or more. No person shall deserve to live in poverty and squalor because of being deprived of the chance to earn for himself. The further two rights, that is right to shelter and right to nutritional food, are covered under the same umbrella. These two rights are considered to be the basic rights along with the right to livelihood. The next right is right to choose one's partner. This right was observed in the case of Lata Singh versus Union of India, where the female got married to a person in an intercaste marriage. The marriage was opposed by the family members, which led to huge fight, violence and chaos in the two families, including the threat to the life of the husband and the relatives. The court observed that the right to marry a person of one's choice is based within the Article of 21 of the Constitution. The court also directed the police to take action against the family members who harasses or threatens or performs any kind of violence against the petitioner, petitioner's husband or petitioner's relatives. The current jurisprudence has gone up to protect interfaith marriages between two different religions under Article 21. Moving on, the right to reputation. In the case of Subramaniam Swamy versus Union of India, in this case, petitioners challenged the validity of criminal defamation under Section 499 and 500. The court examined the meaning and interpretation of the terms defamation and reputation, and it held that no person shall be shunned in front of the society. Next is the right to grow abroad. In the case of Satwan Singh Sahani versus D. Ramratnam, in this case, the petitioner carrying out the business of import, export and manufacture of automobile parts was asked to surrender his passports when it was necessary for him to go abroad. He filed a petition under Article 32 regarding infringement of his rights under Article 14 and 21 of the Constitution. A person living in India has a fundamental right to move abroad, and taking away his passports will lead that government is depriving him from his right to move. The other landmark judgment which we are going to see today is the case of D.K. Basu versus State of West Bengal. It addresses the issues of custodial death, tortures and infringement of fundamental rights. The rights covered under this case are rights against illegal detention and right against harsh living conditions of prisoners. In this case, the Supreme Court provided certain guidelines that needs to be followed by all the police personnel and authorities while arresting a convict or an under trial. And hence, it is important to know that his rights are not violated. The next is right to privacy. Right to privacy sounds like a very basic and obvious right, but it has not been recognized as a distinct right by the government, as it was not merely mentioned in the Constitution of India. Over time, there has been growing recognition of a person's autonomy over his own personal body, mind and information, and due emphasis are given on the same. In the case of Mr. X versus Hospital Z held in the year 1998, the appellant in this case was found to be HIV positive in the blood sample. This fact was disclosed by the hospital to the others but without appellant's express consent. Due to such disclosure, the appellant's marriage with Miss Y called off, and he was shunned by the society. The aggrieved person approached the National Consumer Redressal Disputes Commission, claiming that there was a breach of confidentiality on the part of the hospital. But his complaint was dismissed. The appellant further approached to the Supreme Court that the duty of the care of the medical professionals as well as his rights to privacy were violated. The court held that the appellant's right to privacy was suspended as it was necessary for Miss Y to know about the facts, as she was about to get married and bound to affect her life as well. It was held that medical professionals' duty to maintain confidentiality could be breached in cases where public interest is at stake. The next one is right to health and medical assistance. Right to life, of course, comes with right to proper health and medical assistance. It is an important and primary prerequisite to living a full life. The next is right to sleep. All of us love sleeping, right? But do you all know that right to sleep is a distinct part of one's fundamental right, which protects against action of the state leading to the unlawful deprivation of person's sleep. In the case of Ram Leela Maidan incident was his home secretary, which led to the establishment of this right. The next one is right to die. Right to life confers upon the person the right to full life and dictates that the state cannot interfere in this right except through procedure established by law. But what if a person chooses to end his own life? Can he not interfere in his own right to life? Section 309 of Indian Penal Code 1860 criminalizes this act by an imprisonment of 2 years and fine or both. Section 306 meanwhile criminalizes the abatement to suicide. We might see that with such a view is inhumane because a person, especially one who is about to end his life with depression and frustrated, is criminalized for attempting suicide. A person has a right to life should naturally imply that the right to end his life too. Such a view was taken in the case of P. Rathinam versus Union of India. Here comes the concept of euthanasia along with right to die. The term euthanasia is derived from Greek word eu, that means good, and thantos, which means death. It legally means good death. It is a practice of ending the life of a person suffering from an incurable disease but still breathing, thus going through great agony and distress. It helps him or her go through gentle or painless death instead by either an act or omission or her body. It is thus also known as mercy killing or assisted suicide. There are two types of euthanasia. First one is active euthanasia, which involves something to a person to end his life with their consent, for example, giving an injection. And passive euthanasia includes withdrawing medical services with the intention to end the patient's life. In other words, it means doing nothing or something to a patient which, if done or not done, would have saved his or her life. For example, stop feeding the patient. The concept of euthanasia was observed in the landmark judgment of Aruna Shanbag versus State of West Bengal. In this case, the 25-year-old staff was sexually harassed at her workplace, and which led her to vegetative state for a period of 37 years. The issue was raised that being in a permanent vegetative state, can she be given passive euthanasia? The court said that in this case, where a person is in continuous vegetative state, can't be, and the only option here was not feeding her, and this can't be done because that is not justified to her, because the right to die comes under the concept of right to life. Further right is right to get pollution-free air and water. Without clean drinking water, we can't even live half a week, and without air, we can't even live half an hour. It is very important to have access to pollution-free air and water for a sound mind and body. In the case of MC Mehta versus Union of India, in this case, there was an oil and gas leakage from a unit of Shriram Foods and Fertilizers, and the issue was observed that led to the death of many of the people. The court held that industry is liable to pay compensation of Rs 20 lakh to the victims. It is also ordered that the establishment of expert committee to overlook the operation of the industry. It was directed for all the workers to be properly trained and for loudspeakers to be installed in the premises to warn people in case of leakage. In the case, next is the prevention of sexual harassment of women in working ways. When we think of a good life, it probably means living in respect with community and in unbiased situations. However, in the patriarchal society, women are often treated as sexual objects, means for the pleasure of a man, and it leads to unwanted sexual advances towards them. In the case of Vishaka and others versus state of Rajasthan, in this case, a social worker was sexually assaulted in Rajasthan, and it contended that sexual harassment faced by the women in their workplace was in violation of fundamental rights under Article 14, 15 and 21. The judgment said that the Supreme Court issued that various guidelines should be followed by every workplace, especially for protecting women. The next is the emergency and Article 21 of the Indian Constitution. Emergency refers to situation where immediate action is required by the authorities in the state to prevent any dangerous conditions involving internal rebellion, external aggression, or financial bankruptcy. In India, an emergency can be of three types: national emergency, failure of constitutional machinery, and financial emergency. Article 359 of Indian Constitution empowers the President to suspend the fundamental rights of the people given in the Part 3 for a specific period of time. However, this is not without any exceptions. Right to education. This is a fundamental right enshrined under Article 21A through an amendment. Life without education means mere animal existence, as it is education that broadens the horizons of a person's mind, making him capable of learning and earning a livelihood, but also living a life with happiness and respect, and a mark for himself in the world. Coming to my conclusion, the right to life and personal liberty has a wide ambit, which is only growing over the period of time. There has been increasing awareness about various aspects of life, and he or she is entitled to control them, with enhancing the quality of his or her life. The right to life and personal liberty has been described as heart and soul of the Indian Constitution, and it certainly proves to do so, representing the very basic necessities of a human life. Thank you.
So Pushti, thank you very much. It was nice hearing the entire Article 21, and I'm really happy कि आपने कई सारी अलग-अलग dimensions उसकी खोली हैं, because right to life article apparently it looks like a small one, but it's a bundle of various rights which we daily enjoy them. So thank you very much. Small token from Hammurabi team.